Hello and welcome to Solidum Lawyers channel. Today we will delve into the general principles of administrative law in Ecuador. Join us. Administrative law is fundamental to understanding how the state is organized and operates. In Ecuador, these principles guide administrative action and also protect citizens from public administration. Today we will explore everything from legality to impartiality through efficiency and responsibility. These concepts are essential for every legal professional, students, and citizens interested in their rights and duties in relation to the state. When we talk about the principle of legality in the context of administrative law in Ecuador, we refer to a fundamental rule that permeates all actions of the state. This principle is based on the idea that every action, decision, or measure taken by any entity or public official must have a solid and clear legal basis. In Ecuador, this principle is much more than mere formality. It is the heart of the fair and transparent functioning of the state. According to our constitution, and particularly the administrative regulations, the principle of legality acts as a limit to the discretionary power of the public administration. This means that, although public officials have some leeway in their decisions, this cannot be divorced from what the laws stipulate. The importance of this principle lies in its capacity to protect citizens from arbitrary actions. For example, if an authority decides to impose a sanction, this decision must be based on a pre-existing law that clearly specifies the conditions and procedures for such a sanction. This ensures that citizens are not subject to the whim or the personal interpretations of officials, but to a stable and predictable legal framework. In practice, the principle of legality manifests itself in several ways. On the one hand, it obliges authorities to act within the limits of their legal competences, avoiding the abuse of power. On the other hand, it ensures that citizens are aware of their rights and obligations, as laws and regulations must be public and accessible. In the Ecuadorian context, where public administration plays a crucial role in daily life, respect for this principle is essential for trust in the institutions of the state. Additionally, it is a pillar for building a legal system that promotes equity, justice, and transparency. The principle of impartiality is one of the pillars in public administration in Ecuador and plays a decisive role in the way state management is carried out. This principle focuses on the idea that public officials, in all their actions and decisions, must act with objectivity, avoiding any favoritism, prejudice, or conflict of interest. In practical terms, the principle of impartiality means that when an official makes a decision, it should not be influenced by personal interests, family relationships, political affiliations, or any other factor unrelated to the objective criteria established by law and public policies. That is, each action and resolution must be based on facts, evidence, and applicable regulations, thus ensuring fair and equitable treatment for all citizens. Impartiality is crucial because it ensures that administrative processes are fair and transparent. For example, in the context of the public tender process, the principle of impartiality ensures that all participant companies have the same opportunities to be selected, based solely on the merits and criteria established in the call for tenders. In Ecuador, this principle is not only an ethical expectation but also a legal mandate. The Administrative Organic Code clearly establishes that officials must abstain from participating in decisions where they may have a personal interest and must act with total transparency and equity. However, applying this principle can present challenges, especially in situations where political or social pressures are strong. Therefore, it is essential to have control mechanisms and accountability such as audits, review processes, and complaint channels to ensure that impartiality is a reality in public management. The principle of efficiency in Ecuadorian administrative law is a fundamental concept oriented towards achieving the goals and objectives of public administration effectively and efficiently. This principle is not just an ideal to be reached but a mandate that guides the action of governmental entities in their daily work. In practical terms, the principle of efficiency implies that each action taken by public administration should be directed towards achieving concrete and beneficial results for society. It means that policies, programs, and services must not only be properly designed and executed but also must meet their objectives in a timely manner and with the optimal use of available resources. In the Ecuadorian context, this principle gains special relevance due to the challenges the country faces in terms of social, economic, and environmental development. Administrative efficiency is reflected in the state's capacity to respond to the population's needs, managing public resources in a way that maximizes their positive impact. For example, in the field of public health or education, efficiency is measured by the capacity to provide accessible and high-quality service to all citizens. Furthermore, the principle of efficiency is closely linked to transparency and accountability. An efficient administration is not only one that achieves its objectives, but also informs and is accountable to citizens about how and why it makes its decisions. In this sense, efficiency implies a commitment to clarity in a public management, allowing the population to evaluate and participate in the administrative process. However, achieving efficiency in public administration is a constant challenge. It requires adapting to changing contexts, implementing innovative practices, and continuously evaluating and improving processes. In Ecuador, the path towards efficient administration involves a coordinated and sustained effort both by officials and citizens to ensure that the state fulfills its role optimally. The principle of responsibility in administrative law is an essential pillar that ensures the proper administration of justice and the adequate functioning of the state. This principle holds that officials and public entities must be accountable for their actions and decisions and face legal consequences if they act illegally, negligently, or contrary to the public interest. In Ecuador, the principle of responsibility translates into a mechanism of control and balance, where administrative acts are subject to review and, if necessary, sanctions. This is crucial to maintain trust in our public institutions and ensure that officials act with integrity and transparency. When we talk about responsibility, we are not just referring to the possibility of administrative sanctions, such as suspension or dismissal from office. It also encompasses civil responsibilities, such as the obligation to compensate for damages caused by illegal or negligent actions, and criminal responsibilities in case where an official's conduct may constitute a crime. This principle is particularly relevant in situations where citizens' rights may be affected by the actions or omissions of public administration. For example, if an official issues a resolution that violates a citizen's right, not only should that resolution be annulled, but the responsible individual should also be investigated and sanctioned. In practice, the application of the principle of responsibility implies a robust system of audits, inspections, and complaint mechanisms that allow citizens to report and seek redress for wrongful acts by the administration. Moreover, it implies a commitment by officials to always act in accordance with the law, avoiding any action that could cause harm or prejudice. This principle serves not only to punish but also to prevent. Knowing that they can be held accountable for their actions, officials are more motivated to act ethically and in accordance with the law. In this sense, the principle of responsibility is both a control mechanism and an educational tool to foster a culture of legality and respect in public administration. In the field of administrative law, the principle of transparency is fundamental to ensure an open and accessible public administration. This principle is crucial because it establishes that all actions, decisions, and procedures of the state must be clear and available for public scrutiny and understanding. In Ecuador, the principle of transparency is intrinsically linked to the democratization of information and citizen participation. The organic law of transparency and access to public information is a clear example of how this principle has been incorporated into our legal framework. This law not only obliges public entities to proactively disclose information, but also guarantees citizens' right to request and receive governmental information. Transparency in public administration has several dimensions. On the one hand, it implies the obligation of authorities to inform about their activities, policies, and decisions in a comprehensible and accessible manner. On the other hand, it promotes accountability, as it allows citizens and other control bodies to evaluate the performance of the government and its officials. This principle is especially important in a context like Ecuador, where trust in public institutions has been a challenge. A transparent administration helps to build that trust, showing citizens that their leaders and institutions act with integrity and according to the law. Moreover, transparency is a key element in preventing corruption. By ensuring that decisions and processes are public and subject to review, it reduces the space for illicit or unethical acts within public administration. In summary, the principle of transparency is not only a right of citizens but an essential tool for good governance. In Ecuador, this principle is increasingly being strengthened not only through laws and regulations, but also by promoting a culture of openness and responsibility at all levels of government. In conclusion, we can say that transparency is vital to ensure that public administration acts for the common good and under the fair scrutiny of those it serves, namely all the citizens of the country. Today, as we have explored the principles of administrative law in Ecuador, we have discovered not only the legal basis that govern the action of the state, but also the ethical and moral foundations that must guide our public officials. These principles, legality, impartiality, efficiency, responsibility, and transparency, are not just words in a legal text. They are the essence of what it means to administer justice and equity in our society. The correct understanding and application of these principles are vital. It's not just about following rules, but about fostering a culture of respect, integrity, and service in our public institutions. Each principle we have discussed today carries a promise, the promise of a state that serves its citizens fairly, equitably, and efficiently. At Solidum Lawyers, we firmly believe that transparent and responsible public administration is the cornerstone of a democratic society. Transparency not only fosters trust in our institutions but also strengthens citizen participation in public affairs, essential for the development of our country. We hope this video has provided you with a clearer understanding of these fundamental principles and their importance in our daily lives. We invite you to immerse yourself in the study and reflection of these themes, as an informed citizenry is a key pillar in building a better Ecuador. Before we say goodbye, we remind you to subscribe to our channel to access more educational and enriching content about laws and their application in Ecuador. If you have any question or there is a specific topic you would like us to address, please don't hesitate to leave your comments below. At Solidum Lawyers, we are committed to providing you with the most up-to-date and relevant information, helping you navigate the complex world of law. See you next time, and thank you for joining us.